And greetings. Hello, everyone. We hope everybody is excited to join us here on another edition of Semrush Live. My name is Jason Hennessey with Hennessey Digital. And it's hard to believe that it's been 2 years, more than 2 years now, since GDPR has been introduced as a whole new reality in the world of marketing, specifically digital marketing. And I'm super excited. I'm here to learn, just like everybody else is. This is a world that I am not too familiar in, even though that I personally work a lot with law firms throughout the country, specifically in the United States. But this is taking things to another level, and things are constantly changing. And Semrush has asked me to, to host this webinar where I can bring in like true experts on this particular subject. And so I'm happy to introduce two of the experts here. We have Abbie Clement. She's the head of content at iUbenda. She's an experienced web professional with over 9 years in the IT marketing and communication field across multiple countries. She lives and works in Milan, Italy, but she is in Paris, right?
Yeah.
Nice.
Hi, guys.
Very nice. And then I also have Andrea Giannangelo, if I pronounced that correctly. He's the founder and CEO of iUbenda, and his company has helped over 70,000 clients in 100 different countries with legal compliance solutions, particularly in the field of privacy and e-commerce law. So welcome. Appreciate you joining.
Hello, everyone. Thank you.
So we've got a lot to cover. So this is how this is going to work. First of all, if you are on Twitter or Instagram or Facebook, we are using the hashtag SEMRushLive. Again, hashtag SEMRushLive. We're going to be going through a presentation. Abbie has been nice enough to put together her thoughts, and we're going to be going over that. And there's a lot of stuff to cover. And then what we'll do is we'll save about 15 minutes for some FAQs at the end. But if we don't get to your question, Abbie and Andrea, if you would be nice enough to maybe comment through social media on some of the other questions that might surface.
Absolutely.
Okay.
Sure.
Perfect. All right. So why don't we get started, Abbie? I know you have a presentation to share, and it looks like we've got people from all over the world, from morning to evening to afternoon. So let's get right into this. A lot to cover.
All right. So I'm going to just start sharing, and just bear with me a second here, guys. So, okay. I mean, Jason, you've done such a great job already with the introduction. There isn't too much to say. It's, all three of us here today. And just a little bit about iUbenda. Jason already touched on it, but we're in the data compliance business. So we kind of help companies from small to large. We're talking freelancers to enterprise companies with complying with international data law in an easy way, using our software solutions and our legal text, which is written by our team of international lawyers. So what I'm going to
basically, you just go to a website and you can generate your own privacy policy, terms and conditions, get a cookie banner, all in a very easy manner, and make your website or app compliant very easily. And that's what we do.
So just to go into give you an overview of what we're going to talk about today. So there is a lot to cover because just being in marketing, so many different things can be relevant to, your activities online. So we're going to try to touch on the existing privacy laws with the biggest impact, specifically from the point of view in how it might actually affect you and interact with you as someone in marketing or publishing. Okay, so we're going to be touching on the GDPR. So we had sort of some questions before, and people asked for some recaps and stuff like that. We're going to take a look at the ePrivacy, CCPA and CalOPPA. These are out of the US, as well as the CAN-SPAN. So while we're doing largely the EU and the US, these laws have had major implications globally for new privacy laws, and we're going to touch on that a little bit later as well. So we're just going to dive in, and if you think of any questions along the way, just go ahead and write them, ask them, and we're going to be keeping an eye on those. So first of all, the General Data Protection Regulation, the GDPR. So we're just going to go really basic here. It's a lot, so we're going to just take a quick look at it. So at its most basic, this law, the General Data Protection Regulation, or the GDPR, it specifies how and when personal data should be lawfully processed. So the idea with this regulation was to give more power back to users. Now, personal data under the GDPR is really broad. It refers to any data that relates to an identified or identifiable person, so a living person. This can include pieces of information that, when it's collected together, can lead to the identification of a person. So this means that even, let's say, fragmented data or pseudo-anonymized data can be considered personal data. It includes things like IP address and stuff like that, that when you mix it and match it, let's say you're using various products that belong to a suite, right? You might be tracking location, you might be tracking IP address, with different products within this suite. If this information, when it's collected together, can somehow identify a person, it's also considered personal data.
Even cookies, if they are used for identifying, are considered assimilated to personal data, according to the GDPR.
So under the GDPR, personal data can only be processed if there is at least one legal basis for doing so, which many people might already be aware of. But something that gets lost, because people think of the GDPR, they just immediately think of consent, which arguably is really important. But there are 6 legal bases for processing personal data. So we're just going to take a quick look at them, and then also identify which ones are actually relevant generally to what you guys are talking about.
I mean, just to nail what we mean by legal basis is basically, so what does justify you to process that personal data? Okay, so what does justify you to use that email for sending an email marketing campaign, or what does justify using cookies or selling cookies to identify the user and do retargeting for ads, or any other use that you can do with personal data. So this is what the legal basis is.
So the first one is the one that we all know, which is consent, which is where the user has given consent for one or more specific purposes. And this specific purposes is just to highlight that the consent does need to be specific to a particular thing. So you want to avoid kind of doing this blanket consent to every single thing that I want to do with your data. They need to be informed of specifically what you're going to be doing with it and give consent for that specific thing.
Yeah, so I may have given consent to receiving emails, for instance, but not to being called, okay? Or I may have given consent to receive emails from you, but not from other partners about other products, okay? Yeah. So any use that you want to do with personal data, if you're basing it on consent as your legal basis, that consent needs to be very specific to what you're going to use the data for. And again, typical use cases is for email. It will be an email about a specific product or service, not any product or service, or not from any company, just the company that I'm giving consent to.
Okay, so then the next one is contractual requirements, and I'm going to just kind of blaze through these. So contractual requirements, this is where the processing is needed for the performance of a contract where the user is a participant. So this is sort of just like the fulfillment of a contract. Someone has paid for something, you need to process the personal data in order to fulfill that, this kind of thing. The next
I mean, that might seem exotic, but it's actually very common. Let's say that you're buying from an e-commerce, you're giving your address, which is personal data. There is no need for consent to use that personal data to that address to ship the goods that I purchase, okay? Because there is, I'm executing the contract, which is the sale contract between two of us, and I'm required to send you the parcel through the address that you've given me without further consent or another legal basis. So it's actually quite common.
Do you have some thoughts there, or?
Yeah, go ahead.
We can, okay, just gonna go ahead there. All right, so the next one is legal obligation, and with these, we're just gonna go a little bit faster because they tend to not apply as much. So this is where the processing is necessary for fulfilling a legal obligation. We have vital interests, where the processing is necessary for protecting the vital interests of the user or another person.
And for legal obligation, again, for the e-commerce use case, when you emit an invoice, you're processing personal data based on a legal obligation, which is to issue an invoice. And also, in some countries, you have to store the invoice for multiple years. So even if the user requests you to delete their personal data, you still are obligated to keep the invoices, which contain personal data, like name and address, for a number of years. And you don't need consent for that because you have a legal obligation to hold on that personal data.
So the next one is public interest, and this is where the processing is necessary for performing a task carried out in the interest of the public, and that's typically under official authority, whether it's governmental or whatever given to you. And then there is legitimate interest, which is where the processing is necessary for the legitimate interest of the data controller, which is you, or a third party. However, with this one, there's a caveat. So legitimate interest, the user does have the right to object. So if the rights of the user or the interests or freedoms of the user overrides your interests, then it can't apply. And this is especially relevant where the user is a child. Now, actually, the thing is, of these 6 legal bases, generally, you're looking at 3 main ones that would apply to the marketing use case. Generally, there might be exceptions. And this is consent, contractual requirements, and legitimate interest. So these are sort of the ones that you could take a look at. However, something really useful to note here is that legal bases do need to apply. So it's not that they can be picked at random. It's very difficult to change a legal basis like mid-processing. It has to be justified. And usually we sort of recommend, speaking to a lawyer. Outside of, now consent is sort of a lot more simple, which is why it's relied on so often. But if you're going with one of, let's say, the more exotic bases, it's something that you definitely want to discuss with a lawyer, because you can land yourself in a lot of hot water if you're using a base that doesn't actually legitimately apply to your situation. So with that said, there will always be data processing activities where consent is the safest, best, or only option. Now, just on consent, just to sort of think really quickly, there are pros and cons, of course. Now, with consent, the cons are pretty obvious. If you're relying on that to process data, then if you don't have the consent of the user, then you can't process. So obviously that kind of reduces some of the processing there. And we're gonna get into some practical application a little bit later so that we can kind of see where this might be applicable and take it outside of the abstract. However, the pros of something like consent is that, let's say you might be getting more qualified leads. People are aware of what you're going to be processing the data for. They're agreeing to it. They're informed. So you're getting, let's say, a better quality lead. And you're also creating sort of an air of transparency and increasing trust in that way with your users, which is also good for your brand or your marketing efforts, sort of to look on the positive side of things. So now that we've spoken about that, then that was a really quick sort of rush to look at.
Yeah, one thing I would like to add is remember that the GDPR applies to you in 2 cases. One, if you're a European company, if you're based in the EU, GDPR, you have to apply the GDPR everywhere in the world, even outside of the EU. Okay, unless of course you're operating in the US with another company and you're not transferring data. If you're US or from another country where the GDPR, so outside of the European Union, your obligation is to apply the GDPR to European users. Okay, so that's important to know. And the fact that as a European company, you also have to apply the GDPR outside of the EU is not that well known, and it's easily missed as bit of information.
Yeah, that's a really good point. So just to even break it down, if you're an EU-based company, you have to apply the GDPR not just to EU-based users. So you have an obligation to apply GDPR protections across the board to all of your users, unless you have like a separate US-based company, and even that is kind of murky. If you're or outside of the EU-based company, as Andrea said, and then if you're outside of the EU, you do have to apply GDPR protections to EU-based users. And
this is also like you guys are breaking it down, making it very digestible. But it's really interesting how like they came out with these rules and regulations, and us as marketers like are now having to think like lawyers, right? It's it really is. It's and it happens so quickly.
Yeah. I mean, it's definitely something that it's kind of complicated. And I think like the biggest hurdle is that a lot of people don't understand how to take it from all of these legal terms and like actually apply it, because it takes, both the technology to support these things as well as the legal knowledge.
I got to imagine that there's a lot of people that have been implementing this incorrectly and still implemented incorrectly. And I'm curious to know, like, what are some of the consequences, which you can probably cover a little bit later once you get through the presentation.
Yeah, I mean, actually, that's probably coming up like halfway through. It's not even at the end. We're going to take a look at the consequences for both not just the GDPR, but also the US-based laws as well, because they all have, concrete monetary, even penal, and some other countries' consequences.
Sure.
Yeah, and I know it's a lot, but if you guys think of any questions or whatever, do feel free to ask. So the next up is the ePrivacy or the cookie law, which is a little less famous than the GDPR, but it's incredibly relevant, especially if you are a publisher or just for general marketing, activities, especially content marketing. Now, it's been in effect since 2002, and it was created to put guidelines in place for electronic privacy, including email marketing and cookie usage. Now, right now, since the GDPR sort of came live in 2018, they're supposed to be sort of working together, so it complements the GDPR, and the ePrivacy or the cookie law still applies today. Now, it's been in the works for quite some time to have an ePrivacy regulation, but that's not live yet, and we're going to talk a little bit about the difference between the ePrivacy Directive and the ePrivacy regulation. So unlike the GDPR, the ePrivacy right now is a directive, and directives set certain agreed upon goals and guidelines in place with all of the member states of the European Union, being free to decide how to make these directives into like a national law. Whereas the GDPR is sort of like one law that everybody implements the same way. So because of that, you have like some variations, some slight variations. So for example, some EU member states are still allowing you to collect consent via scrolling, while others say no, it has to be an explicit click on an agree button or something like that. So these are some of the differences. Right now,
or for instance, in the UK, you have to put an explicit reject button on your cookie notice, and right now it's the only country basically that forces you to do that. And tracking these differences can be quite a headache. But basically, every single authority in Europe has been putting out their own guidelines on how to apply this law.
So, like, just to make it simple, as Andrea said, it's a total headache with all of all of the different changes. just to make this simple, generally, most of the member states are sort of moving towards this GDPR inspired interpretation of the ePrivacy Directive, very clearly explicit, consent-based, clear buttons, no real pressure towards granting or rejecting consent or whatever. They're generally moving in that direction. If you want to be safe, as usual, maybe implementing the strictest standards is probably the best way to go. And when I say implementing, just in case we lost some people along the way, first of all, cookies, just to recap, are these little pieces of code and scripts or whatever that can get installed by various services on your site or whatever into the user's browser. So if you're using things like analytics or various other programs you might have running on your site, maybe you have Facebook authentication for people to log into your site or to like or share. A lot of these programs use cookies and they install little tracking scripts into the browser of users. So because this is, again, seen as personal data, consent comes into play. And specifically under the ePrivacy Directive itself, it does rely on consent primarily as the justification for tracking users, for processing their personal data. So generally what's required, which I'm going to get into that on the next slide, basically, is that you do need to inform users, and that's usually done by sort of a notice on the site or a banner that the site runs cookies. I'm sure that some of you have seen it, especially if you're based in the EU, and then the user then has to click like I agree or something like that, for the cookies to be run on the site. Now, so as it says at the bottom here, if you do business in the EU, regardless of if you're based in the EU or not, these laws are going to affect you, and you need to have this sort of thing in place. So looking at what's required, I sort of touched on it, explaining what a cookie is, a small piece of data that's sent from a website or an app, often stored on a user's computer via their browser. You have to get users informed consent. Informed meaning the banner should tell them a little bit about what's going on, that their cookie's being run on the site. And you should also link to a cookie notice that gives them more information, detailed information and specific information. Before you run cookies, you have to block them until you get consent from the user. So if you're not blocking the cookies from running before you get that consent, you're already uncompliant, and you're already processing user data without their consent, and that can land you in a whole bunch of trouble legally. But also, and this is particularly interesting to this industry, is that there are now industry standards. So one major thing is the is IAB, which is the International Advertising Bureau, the Transparency and Consent Framework. Now, IAB, the concept, Transparency and Consent Framework is sort of like a project that came about from IAB Tech Lab. And if you don't know who IAB is, it's sort of this organization of, let's say, ad vendors, and their board includes companies like Google and Adobe, a lot of big names that we all know in the space. And when the GDPR sort of came online, as we discussed already, there was a lot to consider on a legal and a technical level that was very difficult for companies to implement. So the Tech Lab sort of came up with this transparency and consent framework to make it easy to pass the actual technical consent from ad vendor to ad vendor. And it's all a lot of, it's all very technical and so on, but basically it's some code and so on that allows user preferences to be passed along an ad network. So from your site, a user can indicate to ad role whether or not they're fine with seeing ads that are targeted based on their preferences or based on their online activity or something like that. Now,
so yeah, just to recap, so let's say that on a typical site, you may have Google Analytics, and potentially some sites will also show ads. What you need to do is that if you're a US company or from anywhere in the world, for your EU traffic, you need to apply these rules. If you're a European company, you have to apply these rules to all your traffic. And what these rules are basically is that you need to block Google Analytics and your ads until you've acquired content. Okay, so Google Analytics needs not to start until the user has had a chance to make a choice. Okay, which could be a positive choice. It could also be a negative choice. Say, okay, no, I don't want to be tracked. So Google Analytics will basically never track them at all. Okay, so this means that you need to put a system in place that stops these scripts from executing and only releases them when, if and when a positive consent has been acquired. Okay, if you're displaying ads on your site, there are some frameworks to help you. And the most important one is for the GDPR/ePrivacy is the Abbie Transparency and Consent Framework, which you put in place and basically makes your ad serving better, okay? Because it will make sure that the content information is passed to the ad vendors and basically will make you exploit better your ad impressions in Europe, okay, especially. Okay.
So something, just to jump in here. So to continue on with what Andrea was saying, it's worth noting that when I mentioned industry standards, some ad vendors will limit your reach within Europe and so on if you don't have this framework in place, because they are also companies that need to comply with the law. So if you're not passing consent, you're not indicating to them that you actually got consent from your users to show these ads. In some cases, they won't, they will just default to non-personalized ads or not even show ads and just limit your reach along
and if you're thinking, no, I mean, I do show ads, but I don't care about Europe. Wait a minute, because you also see that this is also true for CCPA, and there is something similar. So what we just said of under optimizing your ads is also true for the US and California, based on another framework that also Abbie did for CCP.
So what you guys are saying is by implementing this incorrectly could be reducing the revenue that you potentially be making too.
Absolutely, that's without cold. You're absolutely doing that right now, and we're actually, vendors are texting us saying, hey, I mean, we have this problem where, our publishers need to get all of this in place, because otherwise the folks that buy advertising from us are saying, no, either I get the signals that tell me that there is consent and everything is okay, otherwise I don't want that ad impression, okay? So I'm not buying for that ad impression. Or so what they do is they default to non-personalized ads, which are worth a lot less, okay? So it's not like you're not displaying ads, you're just displaying ads that are lower value, lower paid. Okay.
A lot of people are probably not even considering that when they join this webinar. I just want to pause for a second because we're about halfway into the webinar. If you're just joining us, if you signed on a little bit late, the question is, wow, there's so much information here. I missed a lot of this. Is this being recorded? And yes, it is being recorded. You're not missing much. There's so much to talk through here. We're still got another 30 minutes. The replay will be posted on the Semrush website. And if you are following us, if you do have questions, we're going to save about 15 minutes at the end for questions. I see some questions coming in. And if you are live tweeting, we're using the hashtag SEMRushLive. Thank you, guys.
Thanks, Jason. So yeah, just not to lose that point, it's really important to know and to consider. Also, it's just such a simple thing to do, to just set up the software on your site. Literally, it can largely increase your revenues. We had a recent case, we were tagged on Twitter by Snopes, where they found that some various activities contributed, but they found that their ad revenues was improved by something like 70%, just by doing some optimizations in this regard, and making sure that you're doing everything to make the most out of your ad reach in that way. So that's one really important point to take note of. So now we're going to jump over to some of the US-based laws. We've got sort of three to look at here: the CCPA, CalOPPA, and the CAN-SPAM Act. which many people might already be sort of aware of that last one. So the Federal CAN-SPAM Act is a US standard for the regulation of spam email. So it stands for Controlling the Assault of Non-Solicited Pornography and Marketing, CAN-SPAM. And it sets the rules for commercial email and commercial messages. Now, all US businesses that send commercial emails or employ third-party services to send emails on their behalf are subject to comply. And while you do not need consent prior to adding users located in the US to your mailing list or sending them commercial messages, you do need to provide them with a clear means of opting out of further contact. And so the thing is that there are also quite a lot of requirements with the CAN-SPAM. You need to clearly identify yourself. You can't give things like misleading header information. I don't want to go too much into detail. We do have a lot of guides available on this, and we are sort of halfway into the time, but it is something to keep in mind, specifically that this is something that is allowed in the US. It does not apply to EU users. So even if you're based in the US, you can apply the CAN-SPAM Act to your US users, but to EU users, you do need to get opt-in consent. So doing something like purchasing, mailing lists can be quite dangerous in this regard, because you don't know, especially if you don't know where those emails are based. If they're based in the EU, then you're breaking the law by just...
Yeah, so basically right now, Europe and US, when it comes to emails, are two different worlds, where in Europe, you need to get consent for sending me an email specifically on the topic that you're sending me the email for, or from the company that you're sending me the email from. In the US, it's anyone can send any email to anyone. It's completely free, and this has pros and cons. It also, it means that in the EU, it's harder to actually get to send an email, but when you have consent, it's more valuable, and inboxes tend to be a little less crowded, and conversion rates tend to be a little bit better. In the US, you don't have all these requirements, so much easier to get to send an email to someone, but then everyone is doing that, so it's harder to get attention with emails. So pros and cons of the two systems, even though we have to say that the US has been converging towards a more regulated space for privacy. So getting your mind used, even if you are in the US or just not in the EU, getting your mind used to these rules may prepare you better for the future. Yeah. Because definitely more regulation is coming everywhere. And we have already a GDPR like in Brazil, Japan is following, so Australia, so
towards the end. But so just one common violation of these rules with the CAN-SPAM, as lax as it appears, is a complicated opt-out process. So the CAN-SPAM is quite generous, but it does have rules. And the opt-out mechanism that you provide to the recipients of your emails, it cannot be super tiny, faded, or disguised. And it needs to be free. It can't be behind a login process. They must be be able to see it clearly and know what it does. And
remember to put a physical address, which is also a requirement. So you need to have in the footer of your emails, if you want to comply with the CAN-SPAM Act, you need to have physical address and unsubscribe link. So that's the only thing that you're asked to do. But
a physical address, you said?
Yeah.
So if you have an e-commerce website that doesn't have an address, can you?
You need to get an address.
You need one. Interesting.
Might be like a PO.
Or you can accept being susceptible to a potential fine at some point. You can also.
I'm sure after you get slapped one time, you'll find an address, right? Yeah.
So we're going to jump ahead and look at the CCPA and CalOPPA. Now, California's most well-known privacy laws are some of the most robust in the United States. Privacy laws in the US tend to be more on a state-to-state level. For now, as Andrea hinted at, there is a move to do sort of like an overarching law. Now, they're both relevant to you if you likely have users that are based in the state of California. So CalOPPA requires commercial websites and services to have a privacy policy. And this is just sort of like a very basic overview of what it is. There's a lot more that goes into it, but in the interest of time, the document must clearly state what information is collected, who it's shared with, also things like the purposes, why you're processing the information. You should disclose how you respond to do not track signals from web browsers. And you must include the effective date of your privacy policy. And as I hinted at, there's a lot more that goes into the basic requirements of a privacy policy. Again, something that we can link to in the chat a little bit later, because we do have some guides on this. But we don't want to spend too much time. But the general idea is you need to have a valid privacy policy that informs the user of how you're using their personal data and why, who you're sharing it with, and any rights they might have, any ability to opt out of things and stuff like that.
And you may be asking yourselves, like, okay, but let's say I mostly do traffic in the US. Do I have to apply GDPR? Or, okay, I mean, like, do I have to apply CCPA and CalOPPA only to California users? Or, I mean, maybe I don't want to have California users. So what is the scope, okay? And the idea is that either you block traffic from these locations, or from California or from Europe, or there will be the possibility that a user from those locations will visit your site, okay? So this is something that you have to face. And when it comes to California, the law asks you to basically put in place these measures like privacy policy and else if you may have a California users. And again, either you block those, or you end up applying it just to everyone, or you need to put a system in place that detects whether a user is Californian or not. But it might not be worth it. I mean, these requirements are not the end of the world. So sometimes it's just easier to apply them to everyone.
Yeah. So yeah, I mean, I agree with Andrea saying, like, if you're it's a lot of effort to just, if you're going to set up these kind of systems to comply with the law, which you have to if you have California users, it's sometimes not worth it to like figure out specifically how to exclude it and just apply to them and not to anyone else, especially if other states are moving towards doing that. If you do think that it's applicable to your case or it's worth it, you have the option as well.
Yeah, and I think it's worth mentioning that there are services like ours, but I mean, not only ours, that just give you this basic compliance. If you have basic compliance needs, you can get all of you need for free. So it might worth checking it out, and maybe it's not, I mean, it's less bad than you thought it was.
Yeah, a lot easier to implement. So then, so this is the one that maybe you've heard about because it's quite recent. There was a lot of talk about it, which is the California Consumer Protection Act, the CCPA. Now, the CCPA grants additional rights to users that previously didn't really have, such as the right to be informed, the right to access the information you've collected about them. And then I say here, perhaps most relevant to marketing is the right to opt out. But I wanted to sort of give like a quick look at the rights that the consumer has under the CCPA. So one is the right to be informed, and that has to do with, you know, how and why you're collecting their personal data, the categories of personal data that you're collecting and sharing, the purpose and how they can object to the selling of their data. Then there's the right to access. So that's the right to access, you know, information that you've collected about them. Then the right to portability, which is sort of related to the right to access, which is the right to be able to get that information in a format that they can share with another company or keep or whatever. Then there's the right to be deleted, the right to opt out, the right to opt in, and the right to not be discriminated against. And that last one just means that they have the right to request these things without you discriminating against them, right? So that's a mouthful. Now we're just going to look at the main ones.
And I mean, for the record, these rights are quite similar to the rights that you have to give according to the GDPR. So they overlap quite a bit. So at the end of the day, if you're operating on internationally, you're able, at least US, EU, to kind of uniform how you respond to these requests. Okay,
it's
again,
really,
not completely, but
it's really fascinating as you guys are talking. Like if you're like a US based e-commerce website that's selling stuff and you're in Wyoming, like to comply, you almost have to like block the EU, and then you also block California as though it's like its own country, right? It's interesting.
Yeah, even though again there is talk in the US to do a federal law,
level, which we're gonna,
I mean it's coming. We don't know when, but at some point it will materialize.
I mean, ideally, like if you, that's the thing, like not to be like with any particular product, but ideally this is where software has to fill that gap because it is complicated, and blocking EU traffic is quite profitable in the e-commerce space, and that's kind of coming out. It's worth quite a lot, and also California, it's a large state. I mean, there's a general push to go there, knowing that many other competitors might just block the traffic. It's an advantage to know which software to use, just set it up, and then be able to
open up a market.
Yeah.
All right, so we have about 5 more minutes of the presentation, and then we'll stop for questions. So, sorry for interrupting you.
I might actually need. Let's try.
Let's try to make it. Let's try.
All right, guys. Sorry about that, because we're actually the interesting part, which is how just like some simple ways to comply, because it's a lot. So just to get an idea of what we want to do here. So anyway, the right to opt out under the CCPA, it's an important one that's given to Californian users. So the right to opt out of any processing that can be considered a sale of the data. Now, sale doesn't have the usual meaning under the CCPA. It just basically means sharing the personal data for any profit, whether that profit is money or not. So just sharing their personal data with a third party, whether it's through analytics or whatever, for ads or whatever, that's considered a sale under the CCPA, and therefore they have the right to opt out. So as Andrea mentioned before about these cookie notice and IAB framework and ad networks limiting your reach, this also applies to Californian users. So actually in the EU, for the GDPR, it's the Transparency and Consent Framework, but IAB also has the US Privacy Framework for specifically for the CCPA and for Californian users, so for this use case, so that you're not missing out on ad revenue there.
Yeah, so what happens basically is that if you're showing ads and you have a visitor from California, the ad vendor will most likely not serve personalized ads unless you give them the signal that you've displayed a notice about, and you basically you've done your requirements for CCPA. Which is, it's very simple actually. It's just telling users that they have the possibility to opt out from sale and link the privacy policy. It can also be just adding a link to the footer. So it's actually very, very simple. And then you need to send this signal through a JavaScript API. But again, if you're doing ads, this stuff, like stop what you're doing and make sure you do this right, because you're leaving a lot of money on the table, and more as days pass and more vendors get to do this.
Exactly. So, and just a quick note, in the case of minors, so children under 16, it's not the right to opt out. They have the right to opt in. So you can't start processing their data until they opt in because they're minors. So that's just a quick note. So going straight ahead, now actually I wanted to have a little discussion about what happens where the CCPA and GDPR both apply, but Andrea kind of touched on that about, you can block.
Yeah, I think you need to know that there are cases where if you're a European company operating with a user from California, you have to actually apply both, okay? So you have to harmonize between the two.
Yeah. And there is software to help you do that, even aside from ours. But it's worth noting that sometimes both can apply. Okay, so we're looking at the consequences of non-compliance. So for the GDPR, we have fines up to 20 million or 4% of the annual worldwide revenue. You have sanctions.
Whichever is higher, actually. So.
Wow.
And then you have sanctions like official reprimands, as well as periodic data protection audits and liability damages. Now, those audits, it sounds like not much, but it can really suck. Let's say you have an entire database of personal data that was collected in a way that's deemed invalid or non-compliant, and there's a data audit. There exists a possibility that you can lose that entire database.
Yeah, and this could be for your e-commerce, this could be your mailing list. So you may lose your entire mailing list, which is even worse than the fine. Okay?
Sure.
It may really cripple your business, so watch out.
Mm-hmm.
Right, and just like for some quick ideas, fines have been really, really nasty. Fines have been handed out. Some of the famous was, and also towards U.S. companies. So it's not simply a case of it's only EU companies. Like Google got fined something like 56 million. The Marriott got fined 123 million. And while we're talking about these, and Facebook is they're still doing some investigations, WhatsApp, some big names, but also it's worth noting that it's not only big companies that are getting fines. So you have like the Spanish Data Protection Authority handed out like 80,000 fine to Orange. There was a 1,500 euro fine to some smaller businesses as well. One was a gym. There's a telephone company, like much smaller companies are also getting fines. I'm just kind of like looking at some of them. Quite a few companies have gotten fines. So it's not just that they're only giving it to big companies to make an example, but if someone complains that you've been handling the data in the wrong way, they look into it, and you can get slapped with a fine.
Got it.
Yeah. So
I think we have maybe 1-2 minutes. So I agree
yeah.
that
So just going ahead really quickly here, because I think that also a lot of the questions is how does this apply in a practical way? Really quickly, the CCPA has a lot of fines. They seem a lot smaller, but with the CCPA, the fines apply per individual violation and per customer. So it
so per user, I guess. If you did wrong on like 1,000 users, you have to do a multiplication of those amounts.
So that one's huge. And all of these laws, the violations, they allow the users to bring lawsuits against you. So that's also another thing. So aside from the fine, you might also get sued. And similarly for CalOPPA, the FTC can bring enforcement action against you, and the government can bring suit. Now, just going really quickly to the practical ways that you can comply as a marketer, because that was a lot, and it was very abstract. We're just going to look at like 5 really quickly. So one is to have clear and easy email opt-out for both EU and US-based users. So this is sort of just giving a really broad thing. Now, we do want to remember that with EU-based users, they do need to opt in. But even after they've opted in, you do need to give them a clear way of opting out. So you want to have clear, visible, and easy options to opt out of further communications in your marketing email. So we just have a little example here of a sentence that can work. And you want to be sure to set up an email management system. Sorry about that. Set it up so that the user can opt out without needing to log in, right? So that sort of covers you there for canned spam and also for the opting out requirement of EU law. Jumping in really quickly, and again, these slides will be available for everyone to review. So secondly, you want to make sure you're getting opt-in consent for your EU-based users. So you want to make sure that your opt-in mechanism informs the user clearly and correctly of your intentions. You can't use pre-ticked checkboxes or combine different purposes. And I'm going to just show a picture to make everything clear. And you want to make it clear to the user that they're consenting to your newsletter or whatever it is completely optional. So here's a visual example. So what you don't want to do is you don't want to group something like your terms and conditions and then your contact permission together, and then you just have them provide consent, one blanket consent for everything. I know a lot of people do that, and that's completely wrong, and it can make you end up with a nasty
And
fine.
again, totally fine in the US, but in the EU, no.
In the EU, you can't do that. So in the EU, you do need to have separate checkboxes. Even if it is on the same form, you do need to have a separate one for the terms and conditions, and then the contact permission, and you do need to state that it's optional and have a separate one for each one of the purposes. So this would be the correct way to implement that.
Abbie, I think we need to wrap it up. Do you have like one last thing you want to say?
We have 3 more minutes.
Yeah, go for it.
We don't.
Well, take one more minute, and then we'll take a couple questions.
All right. Thank you. All right. So the transparency, you want to make sure that you have all the disclosures and you clearly identify yourself, have a valid privacy policy, make sure that your endorsements are non-misleading and fully disclosed. Inform users when you're given an incentive. So this one's pretty well known. You also want to clearly identify yourself and your business with accurate, up-to-date contact information. We didn't super get into this, but the GDPR makes this a specific requirement. You must be unequivocally identifiable.
Yeah, the endorsement might be interesting for this audience, because if you are writing articles and it's a review and you receive the product or you were paid for the review, you must disclose it. Otherwise, I guess it will be, and there are US laws again that force you.
Otherwise, you're breaking both US laws and international. So it's actually an international law for this one. So you want
big
to make
mess.
Sure that you do that. And lastly here, so it seems that we're going to make it, is to have a consent management platform in place on your website. And this sort of goes into what we were talking about before. If you have EU-based users as well as California-based users, you have cookies in use on your site, and you most likely do. Not having a cookie consent management solution on your website could mean that you're violating user rights and that you're losing a lot of ad revenue that you could be accessing otherwise. And you want to make sure that it allows you to do all the stuff we mentioned before, inform users, block cookies, all of that stuff. And then also you want to make sure that it supports the US privacy framework, and both, but if you have US-based users, you want to make sure it definitely supports that. And this is what a CMP, content management platform, can kind of look like, one of the interfaces. So they see the banner and they click on it, and then it gives them the option to toggle preferences for the type of processing. So if they're okay with their personal data being shared or not, if they will allow you to run measurement cookies or advertising tracking cookies and stuff like that. So that brings us more or less to the end. We don't really have time to go super into this, but in terms of the privacy,
I mean, as we said, there is more coming for sure. I mean, we're all looking at.
It almost seems like first of all, I commend you both, because to pack this kind of information in a 30-minute presentation, we could probably do a 3-day boot camp and talk about all of this stuff, right, all day long. So nice job, Abbie. Andrea, appreciate your insights here. We're going to take a couple questions here, and heck, there might even be a part 2 to this, possibly. We'll
Why
see,
not?
right? If there's enough.
No, I just wanted to say really quickly before we get into that, it's just that just keep in mind that in terms of the future, this is where everything is going. Like all this complicated legal stuff, it's all kind of going there with India, Brazil, Japan, even Dubai, all coming on with privacy laws. So it's definitely something to keep in mind.
Perfect. All right, so let's take a couple questions, and if we don't get to your questions, there's a lot of questions. If we don't get to your questions, please, you could either use the hashtag SCMRushLive on Twitter, and Abbie and Andrea will try to field as many as they can, or we'll give their information and maybe you guys can reach out directly. So first question, let's see here. How can GDPR law be enforced on a US company that has no physical presence in the EU?
Yeah, as to Facebook or it depends, of course, on if you have a very small amount of traffic from the EU, the likelihood of something happening, of course, is small. But at the same time, if just one user reports to their local authority, then the local authority has to investigate you. Okay. And you'll be asked to respond to European law enforcement tribunal or whatever. So, I mean, it's the same. It's just that it's going to be from the EU side, even worse.
Got it. And Google is a good example of that, right? Yeah. Jeff asks, how much of this applies if your website is only collecting Google Analytics data, which does not include any personal data?
It does include them, because even a cookie is a personal data. As we look at the definition at the beginning, it's enough to have something that makes the user identifiable. And Google Analytics is exactly that. And unless you de-anonymize it completely, and then becomes almost useless, then you are collecting personal data and you're subject to everything that we said. So you need, in Europe, you need to block it, and then have a cookie banner. In California, you need to allow users to opt out from sale, and then you have to have a privacy policy that tells that you're using Google Analytics.
Remember, even something like IP address is considered personal data, and remember, again, aggregate data. If data can be paired with other pieces of data to sort of identify the user, then it is personal data as well. So it's a very, very broad definition, and yes, analytics does fall under that, as Andrea said.
Yeah. All right. So on top, digital marketing asks, so you mentioned that we can't force someone to consent. Is restricting access to the site until receiving consent a valid way to implement that? And I know we talked about you don't want to do that because you restrict revenue.
Yeah, no, that's called a cookie wall, and the European Data Protection Board just a month or so ago said explicitly that that's not allowed. So either you completely block traffic from a country or a location, which you can, but you cannot subject the entrance to a wall that says, okay, if you want to enter, I have to track you, otherwise you cannot enter. So either you block everyone, or you cannot block just the ones that don't accept cookies.
But you can, just to add one quick clarification here, because sometimes people mix up terms and conditions and privacy policies and all this other stuff. If it is that you're trying to have people agree to your terms and conditions, which is something different and can't be used to override the law, right? That's something completely different that deals with your own rules for how your site can be used.
Yeah, I mean, I guess you're getting into a complex scenario and you want a lawyer to aid you, for sure.
So in general, no, you can't do it, as Andrea said. But I know that some of the cases that you might be thinking of might be something like the Washington Post does this thing, or some of these publications where, in order to access, to get to their site, you have to like disable ad blockers and allow cookies to run and stuff like that. There's some cases that are towing the line where if your service is a paid service, you're saying, okay, only paid members can access it, but if you want to access it for free, then we need to run ads. That's something that you should really discuss with a lawyer. Some websites, US websites, have been doing it, but it's kind of tricky. So if that's sort of what the person was thinking about, you want to
do two more. I've got two more questions. Room for two more. So can a US-based company store user information like name, address, email in the US, or does the data have to be stored on a server that's in the EU?
If right now, we just had the news that something called Privacy Shield that will allow you to store it in the US if you comply with this set of requirements and subscribe to Privacy Shield. All of this has now been invalidated by the European Court of Justice. So until 2 weeks ago, yes, now you cannot do that anymore right now. I mean, unless, it's kind of complex to do. So you can, but you need a legal basis, okay? So one of those things that we said at the beginning, or you need something called standard contractual clauses. So at the end of the day, it's much simpler to just store everything in the EU. If you need to handle the data from the US, read the personal data, read your analytics, then you need to put a system in place to do that. And again, it's something that you can research. It's definitely a good question to make yourself.
But just to say, standard contractual clauses and BCCs, do apply, and there is hope. You can technically do it.
Yeah, no, you can totally do it. It's just, it used to be simpler until 2 weeks ago.
It was
Now
easier.
it's a little bit harder. Yeah.
All right. One more question, and then I'm going to ask you guys to give some information on how people get in touch with you, because I'm sure there's more questions. So is there a way to test for compliance, like GDPR? Like, is there any tools, or how do you test for this?
Yeah, I mean, we're actually working on something like that, and plus, I mean, our site, you can also get your site scanned already, and it gives you some basic alerts. Otherwise, I mean, you can still go to a lawyer and make sure that they, they give you an assessment. Yeah, I mean, but again, reading and this webinar already gave you a few tips, so you can also get informed on your own, and at least make a little bit of culture on the topic for yourself, so that even if you go to a lawyer, you're a little more prepared. This is daily stuff, so you need to own it, just like you owned SEM or SEO. This is something you need to own as well in 2020.
Yeah, it almost sounds like the financial the financial impact is greater if you ignore this than if you just kind of comply.
Yeah, exactly. I mean, it's not the end of it. It's, you need to know what to do, and it's tedious, annoying, but it's not the end of the world. And once you do it, you're doing,
Yeah, I mean, it's a little bit of a pain in the butt, but to not do it is way worse, and it actually affects your pocket. And just like I saw really quickly here that someone asked if their EU traffic is under 5%, if they still have to worry about it. And yes, like if you have users from these regions, you do have to comply. It doesn't matter if it's a small percentage. Otherwise, if they're not a profitable percentage of your market, then you might just need to block this region.
All right, Abbie, Andrea, thank you so much for your expertise, for your time. I learned a lot. I'm sure everybody else on the webinar learned a lot, and maybe there will be a version 2 of this webinar with all the questions that we didn't get to. So having said that, if people do want to get in touch with you, how do they do that?
I mean, you can visit our site, ayubenda.com, or just tweet at ayubenda, or I mean, I guess just tweet at Semrush, and then we can be tagged.
Perfect.
Yeah, you can just reach out to us on Twitter, and we'll be happy to answer. Pity that it took so long, the presentation. We couldn't get to more questions, but it was long.
It was great. You did a great job. And again, if you are on Twitter, again, the hashtag is SEMRushLive. Give us a shout, tag SEMrush. Let us know what you learned, what kind of value you got from this webinar. I learned a lot. And just to kind of let you know that this will be rebroadcasting, so we'll be putting it up on the SEMrush website. So if you joined a little bit late, that's okay. You can still see the full replay. And then I also just want to mention that we do have some amazing webinars coming up in 2 days. We've got a technical SEO and content optimization webinar with some experts, Viola Eva, Jono Alderson, a few other people will be on that one. And then on August 4th, we're going to be talking about EAT, Expertise, Authority, and Trust in the age of coronavirus. And that's with Lily Ray, Nick Ranger, and Peter Mead. So again, thank you so much, Abbie, Andrea, appreciate your time. And we'll see you on the next webinar.
Yeah, see you.
Bye-bye, see you next time.
Bye, guys. Hope it was helpful.